We'll wait for another 2 minutes for everyone to join.
Sure.
We already have questions. Should we start then? I guess.
Sure.
Yeah. So hello everyone. This is the second session out of the three-day sessions that we've been having. So the first session we had yesterday on competition law, which was the introduction to competition law and policy. Today's session is on the leading cases in competition law. And then tomorrow's session we'll be having on COVID-19 and the role of the competition regulator. Now, Rudresh will, of course, cover leading 9 cases today by the CCI, NCLAT, and the Supreme Court. This will give you a glimpse into how the authorities assess issues and decide based on questions of law and fact. First, I think Rudresh will start with a recap of yesterday's presentation. I believe some of you may have missed that. So a short recap before we go ahead. And of course, Rudresh is a partner designate with the Competition Law Practice Group at LNL Partners, New Delhi. He represents clients before the CCI, the NCLAT, and the Delhi High Court and Supreme Court in both merger control and behavioral matters. He's a graduate from the University of Michigan Law School, USA, and where he was a Mitsui Fellow. He was previously at a top law firm in the US. Of course, you can look up his full profile on LinkedIn. This is just a short, very brief introduction. And this webinar, of course, is brought to you by EBC Learning. EBC Learning, we produce courses and provide courses on demand. Our objective is to help remove hurdles to legal education, to empower you, and to help you, of course, learn and win. We are a subscription-based platform, which means that you get access to all the courses that you subscribe to during the period of your subscription. A few preliminaries before we start the webinar. This video will also be available to you on our YouTube channel, which is youtube.com/c/EBC Learning. Also, you can post your questions in the chat. We will take them up once the presentation ends. And at last, don't forget to share this webinar with your friends and family and on your social networks. I'd now ask Rudresh to start. Rudresh, over to you, please.
Thank you so much. Thank you everybody for joining in. It's good to present the second session of the 3 that we've planned to do. This session is titled Competition Law Through Case Law. So essentially, I'll be covering a few important cases that the competition regime has seen over the past few years. I received very significant feedback yesterday, a lot of praise, a lot of comments. One significant comment I received from quite a few of you was postponing the Q&A to the end of the presentation itself. So today, our aim is to first do a quick presentation for about an hour 10, and then do a Q&A for about 30-35 minutes, if of course there are sufficient number of questions. Uh, I will, if there is anything very significant, for example, if any of you do not understand the basic concept that we are discussing, I'm happy to take a pause and respond to that particular question. But ideally, I'd like to uh, do a good round of Q&A at the end of my presentation today. I thank EBC for hosting us, and I'll start now. So just a quick recap of what we discussed yesterday. Yesterday's session on Introduction to Competition Law and Policy was aimed at understanding the basic concepts of law, aimed at understanding what the regulatory regime is, and aimed at understanding what the basic principles of the Competition Act of 2002 are. I will very quickly recap a couple of things that we discussed yesterday. Number one, the structure of the competition regime in India. The first authority that we have in India is known as the Competition Commission of India. All cases under the Competition Act first go to the Competition Commission. An appeal from an order of the Competition Commission goes to a body called the National Company Law Appellate Tribunal. This replaced a previous body called the Competition Appellate Tribunal. An appeal from the NCLAT goes to the Supreme Court of India. There's another arm of the CCI called the Director General's Department, or the wing. The DG, as we call him, looks at all investigations that the CCI decides to mount against a company or a group of companies. The DG is a wing within the CCI, but also operates at an arm's length distance so as to ensure that there is impartiality and independence. So that's the structure of the regime in India. The powers of the commission, the powers of the Competition Commission are significant. Number one, they have powers to penalize companies and officers, directors in default. Penalty provisions are given under Section 27 of the Indian Competition Act. Essentially, very simply put, a company can be penalized up to 10% of its turnover for a violation under Section 3 of the Act, or for a violation of under Section 4 of the Act. Further, if it is in the nature of a cartel violation, companies can be penalized 10% of their turnover for the period of cartel, or 3 times the profits, whichever is higher. So very simply put, if there is an ongoing cartel for about 10 years, the commission has the powers to look at turnover or profits for the duration of those 10 years. The commission also has powers through the DG wing of the CCI to raid companies and raid officers and directors in default. The powers of raid are indirect, in the sense that the DG has to make a case before the Chief Metropolitan Magistrate, New Delhi. After an order is received from the Chief Metropolitan Magistrate in New Delhi, is when the DG and his department officers can raid company officials or companies itself. Of course, the CMM order is valid all throughout the country. So order issued by CMM Delhi is good enough to raid a company in Bombay or in Bangalore. The commission also has powers to issue cease and desist orders, which is in the sense an order to stop certain conduct and an order to ensure that that conduct is not repeated. So these are the broad powers that the Competition Commission has. There are various other powers, including powers to, for example, order divestments in merger control matters, but those are minor points that we can discuss going forward. The dimensions of the Competition Act itself, there are about 5 dimensions of the Act. We've very broadly and briefly covered each of them yesterday, but I'll still tell you what those broad heads are for all of those who may not have joined yesterday or may have missed a part of it. The first leg of the competition regime in India looks at ex post prohibition of anti-competitive agreements. What are anti-competitive agreements? These are agreements in the nature of horizontal agreements or in the nature of vertical agreements. A horizontal agreement in the nature of a price fixing agreement, or a horizontal agreement in the nature of a territorial allocation agreement or a bid rigging agreement is per se bad in law, which means that the presumption is against the company. if a company wants to establish pro-competitive justifications and wants to establish why they had to enter into such an agreement, they will have to establish on evidence as the benefits that accrued from such agreement and that it outweighed any anti-competitive harm. Under anti-competitive agreements, like we discussed yesterday, the Commission can also look at vertical agreements. When a commission in India or globally looks at vertical agreements, they typically do a rule of reason analysis, which means that the informant or the complainant will have to satisfy to the commission that the agreement causes AAEC in the market, appreciable adverse effect in the market, failing which a case will not be sustained at the CCI. So that's the first limb of the Competition Act in India, which is to regulate and assess anti-competitive agreements in India. The second dimension or the second limb of the Competition Act is ex post prohibition of abuse of dominance. Now, what is abuse of dominance? Very simply put, if a company abuses or uses its market power to the detriment of consumers, competitors, and any downstream entity without any valid justifications, that is abuse of dominance. When an abuse of dominance case is filed at the CCI or submitted at the CCI, one has to establish 3 or 4 things like we discussed yesterday. Number one, you will have to establish that there is actually dominance that the company enjoys. A dominance is tested on various parameters, market shares being one of them. How does one determine whether a company is dominant or not? It's basis the relevant market definition. One will have to first figure out what the relevant product market is, and then figure out what the relevant geographic market is. After one has figured out what the relevant markets are, is when one will assess whether that entity is dominant in that relevant market. Once dominance is satisfied, one will have to look at Section 4.2 of the Indian Competition Act and assess if any of the conduct that they are looking at is in the nature of a indirect or a direct imposition of unfair terms and conditions on the purchase or the sale of goods, if it is in the nature of if the company is indulging in denial of market access, if the company is using its dominant power in one relevant market to enter another relevant market, or if the company is using its own power to limit or restrict the production of goods or the services involved, or if it leads to any prejudice to customers in respect of technical or scientific development. So this is given under Section 4.2 of the Indian Act. That after one has assessed whether a company is abusive or not, the Commission will have powers to penalize such delinquent enterprises. So that's the second limb of the Competition Act. I'll just very quickly turn off a phone that's ringing here. I'm so sorry. Yeah. So that's the second limb of the Competition Act, where the Commission looks at abuse of dominance cases and assesses whether a company which is dominant in the relevant market in India has abused its position or not. The third limb of the Competition Act is ex ante regulation of mergers and acquisitions. Over here, the Commission looks at every large transaction that is notified to the Commission. There are certain substantive tests in terms of financial thresholds that one looks at to assess if the transaction will have to be notified to the competition regulator. And if the financial thresholds are met, you will also have to look at certain exemptions that the merger control regulations provide for, and certain exemptions that the Government of India gives pursuant to notifications that they issue from time to time to assess if those benefits may be accruable to you. Failing which, the Commission can block transactions, can issue notices, and can penalize companies. The fourth limb, sometimes not as strongly advocated, is competition advocacy. It is important for the competition regulator, especially in a nascent regime like ours, to tell the world about its existence, to tell the world about their powers, tell the world about what they can and cannot do, and tell the world about how companies and people should conduct themselves when operating in the market. The fifth and another very relevant dimension of the Act is with respect to advisory that the government or that the CCI can give to various state and central authorities, including governments, PSUs, and state government authorities. So that's also a very, very significant power that the Commission has. They can issue, directions, or they can issue at least advisories where, for example, PSUs are told on how they should conduct tenders that they do, or how they should, operate in the market when they're dealing with, for example, beer companies operating in a particular market. So they have very wide powers. They have powers to review mergers and acquisitions. They have powers to prohibit abuse of dominance. They have powers to prohibit and curtail anti-competitive agreements. They, of course, have powers to do competition advocacy, and they have powers to advise governments both at the central and at the state level. Going on, I will now very quickly start discussing a few cases. And before I start going into those cases, yes, I will. So that's what I was coming to. Before we start going into cases, I just wanted to tell you the names of the cases that I'll be discussing so that all of us are aware of what we are going to discuss going forward. So I've divided this discussion into three broad heads. The first broad head is mergers and acquisitions. The second broad head is anti-competitive agreements. And the third broad head is abuse of dominance. I have covered a couple of cases in each head so that one gets a flare of what the competition regulator does. A 1.5 hour session can never even cover anything beyond the very, very basics of the cases that one has seen at the CCI over the last 10 odd years. But it's a good insight into what the Commission thinks on. It's a good insight to further read, and it gives one a basic understanding of the jurisprudence that's evolving, gives one a good understanding of what to read further and how to read further if one desires to pursue this area or is already, an in-house person or a law firm person practicing in a related area of law. So the cases that I'm going to discuss under merger control are ArcelorMittal's acquisition of Essar Steel. That's the first one. The second one is Power Finance Corporation's acquisition of REC Limited. And the third one is IHH's acquisition of Fortis Healthcare. I will type the names over here right now. Give me a couple of minutes. So these are the three cases that I'll be discussing today under the head of merger control. Now, I wouldn't really go into the facts of the matter as much. I'm, of course, happy to respond to any direct questions that would come my way. But these are the three broad questions, the three broad cases that I'm going to cover. Of course, we are in very interesting times. We are shortly going to be seeing a large notification, hopefully being made by Facebook Inc. for a 9.9% stake that they have proposed to buy in the relevant entity controlled by Reliance Jio. That has probably not still been notified at the CCI because the Commission is operating at bare minimal strength and is operating for very critical work that they cannot delay any further. So, of course, we wouldn't know for certain, but this notification is yet not made and should be made very soon. So yes, very interesting times ahead. There's a lot to learn from this transaction. It's probably the first large deal in the sector. Of course, the stake that they're purchasing is a minority stake, but they would have certain rights basis which this transaction will have to be probably notified. So the first case that I wanted to discuss today is ArcelorMittal and Nippon Steel's acquisition of Essar Steel. So this was actually a joint venture entity that purchased Essar Steel in India. The transaction itself was very, very significant because of the high stakes involved. Eventually, it was about 45 or 48,000 crores that the acquirer spent to make this purchase. Second, it was probably one of the most contested cases that one would see. There was litigation not just at the NCLAT and the NCLT level, there's also significant litigation at the Supreme Court on various issues that the target entity had faced. So this transaction from a CCI standpoint is very, very significant for a couple of reasons. This was probably the first largest deal at the CCI that saw in-depth analysis of the steel sector. Of course, there were a couple of deals notified before this one, but I think the commission went into a very, very serious assessment of this transaction because of who the parties were. ArcelorMittal, like all of us may know, is probably the world's second largest steel maker, if not the world's largest steel maker. And Essar Steel, even though it was pushed into insolvency and bankruptcy in India, it was also and is a very large Indian player in the Indian steel sector. The commission did a very thorough analysis of the deal. And like we had discussed yesterday, they looked at a very narrow definition of the relevant market itself. So they not only looked at the types of products that the parties make, they went further and looked at various relevant markets like hot rolled steel, cold rolled steel, color coated products, tubes and pipes. There were about 7 or 8 relevant markets where the parties had overlaps, and the commission did a significant assessment of those relevant markets. The ArcelorMittal deal was also very significant because of the time constraints that there were. There is a 210-day period that the IBC gives for transactions to close, given the various other litigations that the parties were in. There was tremendous pressure on the parties to get a timely approval from the CCI. And therefore, even from a timing standpoint, once in a while, this is for all practitioners, once in a while, from a timing standpoint, a deal becomes extremely critical because parties expect a very, very expeditious approval of a transaction. Another interesting point, and I think I should discuss it at this stage when I'm discussing mergers, is with respect to the form that one has to file. So there are 3 types of forms that one has to choose from. There is a Form 1, there is a Form 2, and then there is a Form 3. A Form 3 is for certain other purposes, which we won't discuss today, but I'll very briefly tell you of the types of forms over here. A Form 1 filing. A Form 1 filing is a filing where the market shares of the combining parties at the horizontal level are less than 15%, or at the vertical level, less than 25%. So what does this mean? If, for example, there are 8 relevant markets defined, let's assume one relevant market is hot rolled steel for automobile cars. If that is a relevant market defined by the commission, they will assess if the acquiring entity and the target entity combined in the relevant market have either more than 15% at that horizontal level, or if they are in the downstream of each other, whether they have 25% or more. If it is if either a 15% threshold is met or a 25% threshold is breached, a mandatory Form 2 notification ought to be filed. Even though the Act itself says that the parties have the discretion to choose the type of form, but in practice, a Form 1 notification will be rejected if the market shares of the parties breach these market share thresholds. So that's the ArcelorMittal deal for you. AM, NM, that's how we call it. AM, NM acquiring Essar Steel in India, various relevant markets defined, probably the largest steel sector deal in India, the largest global player entering the steel sector in India through AM and NM, and a very detailed assessment of the relevant markets undertaken. So that's the first deal that we have spoken about. I will field all questions after we finish our discussion today. A Form 2 has to be filed when the combined market shares of the parties, either at the horizontal level or at the vertical level, breach a 15% or a 25% combined in that relevant market. Then mandatorily a Form 2 notification has to be filed, failing which the CCI has the powers to reject your filing, and you will have to come back and refile. A transaction typically has to be filed at the CCI because they want to assess the impact of the combination in the market. Even an insolvency matter ought to be notified for a couple of reasons. Many times, a company has gone into insolvency and bankruptcy not because they're not operating in the market. They've gone into insolvency because they've been unable to take care of their debt and payment obligations to banks. So for example, SR Steel over here was a full functional entity. It hadn't ceased operations. And therefore, it was a competitor to another steel player, a group of steel players, in fact, AM, ArcelorMittal, and Nippon Steel. And therefore, a notification even for IBC transactions is mandatory if, of course, the financial thresholds that we discussed about yesterday are met. If you are exempt under law, then you don't have to notify. If you're not exempt under law, then the notification ought to be filed, failing which parties can be penalized. The second case that I wanted to discuss today was PFC, Power Finance Corporation, and its acquisition of a company called REC. It was previously known as Rural Electrification Corporation, and its name was changed some time back, I don't recall when, to REC Limited. Both are listed entities, if I am correct. This deal is also very significant for a few reasons. Number one, this was probably the largest deal in the power finance sector in India. So like some of us may know, there's various types of financing that happens. Bank do institutional financing, they do retail financing. Within institutional financing, they may finance real estate developers, they may finance power companies, they may finance anything else, a road construction company. Retail finance, typically education loans, home loans, housing loans, personal loans. So in institutional financing, there are banks also which operate, but there are agencies like Power Finance Corporation, like REC, that do very specific sector financing, which is in the power sector. So when the parties went to the CCI, the parties rightly proposed a very broad relevant market definition. And that's because in the broader market for financing available, a power sector company can very well go to a State Bank of India and seek funding. And the rates are typically not very different because there's significant competition in the market, and therefore the parties suggested to a broad definition of financing available from banks and other institutions in India. The parties are also required to also offer every other possible relevant market definition that may be available or may be decided by any other regulator or by the parties themselves. So therefore, the parties also defined the narrowest relevant market, which was power sector financing in India. In the power sector financing, PFC and REC are two large players. Public data suggests, and we are counsels to the acquirer over here, so I'll have to speak from what is available in the public domain. Public data suggests that the parties are large players in the financing of power projects in India. They possibly have a combined relevant market share of about 55 to 60%, and therefore it is a very high concentration that the commission eventually approved. Very importantly, I should have highlighted this at the start. This is probably the largest disinvestment transaction that the government of India proposed and eventually did in the power sector. So I'm sure all of us know governments have certain obligations to divest their stakes in government companies. The government of India, through the Ministry of Power, which controlled PFC and REC, decided that PFC will buy out government of India's stake in REC. The stake in PSUs, central government PSUs, is typically held by the President of India through various ministries and is held by the Governor of State for state corporations. Of course, the control itself is exercised through the relevant ministry, over here the Ministry of Power. So this was a large disinvestment transaction that the government of India did. It was approved by a panel led by the Prime Minister of the country, and therefore there was significant stakeholder involvement on this transaction. The PFC REC deal got a record time approval. It was a clean transaction, a clean approval, and the CCI did not order any divestments or any modifications to the deal itself. That is also a power that the CCI has, where it can tell parties to either divest a certain portion of the business if they think there is significant concentration. It can direct companies to, undertake not to do certain conduct for a foreseeable future. It can direct companies to not exercise control over the board of the target entity or of a related party. So in this case, the parties managed to get a clean approval, and this was a large transaction notified and approved last year by the Competition Commission. The third deal that I wanted to discuss, another different sector, very interesting deal, IHH Fortis. Fortis, even though again operational, was in dire requirement of financing. They had certain obligations that they couldn't comply with. I wouldn't be in a position to discuss what those obligations were, but yes, Fortis couldn't have taken care of certain financial obligations that were accruing, and therefore the board of the company decided to sell off. There were various investors who were interested, including a group of other hospitals like the Manipal Group. Eventually, IHH was the chosen bidder, and IHH went ahead and acquired this transaction, acquired this entity, Fortis Healthcare. It operates hospitals across the country and is a significant player in the NCR market. The deal size was about 4,000 odd crores. And why this deal is very relevant, this is probably the first deal in the healthcare sector that the CCI did a very significant assessment of. The parties initially went ahead and did a Form 1 filing basis a broader level market shares that they looked at. Eventually, the parties were directed by the CCI to do a Form 2 notification. In the Form 2 notification, the parties were mandated to do a specialty-wise, city-wise assessment of market shares. I'll just pause there for a second. A specialty-wise, city-wise assessment of market shares, which means that they wanted not only to know what the parties' market shares were, for example, in a particular surgery or in a particular procedure, for example, hip surgery, they also wanted to know what the parties' market share were on a city-wise basis. So they wanted to know if you have 500 surgery, that you do 500 surgeries a day or month in NCR, but they also wanted to know whether you do 50 surgeries per city or you do 700 surgeries in that city. So they wanted to do a specialty-wise, city-wise assessment of the relevant market. So that's how narrow the relevant market can go, is what is critical to understand over here. What is also very critical over here is the fact that Fortis was probably a failing firm. They had finances to operate for very few days, and therefore the closure of the transaction was very critical. There are certain commitments that the parties had to eventually give, post which the commission agreed to approve this transaction. The commitments were broadly two. One was a commitment where certain directors of the combining entity, that is IHH Fortis, would not sit on a joint venture entity that Fortis had with another hospital chain by the name Apollo. So there is a hospital called Apollo Gleneagles operating out of Calcutta. That joint venture is controlled by a group entity. And the CCI said that you will not have common directors on the board of both companies because they are competitors and ought to be competitors going forward in the relevant market of Calcutta. And therefore, they decided and mandated the parties to have that in place. And in line with not having board control, they also mandated certain firewalls. I'm simplifying this for all of us, but firewalls are in the nature of directions that are issued to parties to ensure that competitive sensitive data does not flow between two competitors. And therefore, they wanted to ensure that Apollo Gleneagles and the relevant IHH Fortis entities do not share any pricing, market, customer, discounting data amongst each other. So that's the obligation that the parties are on, and it's available in the public domain. So these are the three broad heads or the three broad topics I wanted to discuss under merger control. I will now go ahead and discuss the second head that I have over here, which is cartels. I am going to list out the cases that are going to be discussed today. These may not be the exact case names, but I'll tell you of what they are known as in India. So I'm going to be discussing two cases. The zinc carbon dry cell batteries case and the cartelization in the airline industry. I very briefly touched upon the second case yesterday, but I am going to go into significant detail today for us to better understand the case and understand why the commission thought the way it did. So the first case is with respect to cartelization in the dry cell batteries. I have already written the name of the case in the Zoom webinar chat. All of you can have a look there. It's called the zinc carbon dry cell batteries cartel. It's very interesting to note how this case started. There's an entity called Panasonic. It's a large, I think, Japanese corporation, if I'm not wrong, and operates out of India. They used to sit on an association called the AIDCM. It's the Association for Dry Cell Batteries. Of course, a group of manufacturers sit on that association. Over there, the association and these companies apparently would collect and disseminate data of production and pricing within the group. So the three players would know what the pricing of the other party would be, and they would know what the production capacities and the production plans of the competitors would be. This is a case decided in, I think, 2018 or early 19. The DG, which is the Director General of the CCI, raided the offices of Panasonic, International, and Everready. Now, we have discussed what a dawn raid is. A dawn raid is a case where parties are raided by the CCI. In this cartel, the first party over here, Panasonic, had gone ahead and done a leniency at the CCI. It had self-reported certain conduct and had told the commission of the existence of this cartel, where they were discussing prices, they were allocating territory, and they were discussing the production figures of competitors. This was reported to the CCI, and the CCI initiated a suo motu case for this cartelization. It is a violation of Section 3 anti-competitive agreements. The DG raided the parties. In fact, the DG raided all three parties, not just the other two complainants or the other two opposite parties, but also the first party which went ahead in leniency. The raid led to a significant addition that the commission got to know of, and immediately after the raids, the other two parties, which is Everready and International, also went ahead and filed their respective leniency applications at the CCI. The case started somewhere around in 2016, if I'm not wrong. The period of cartel itself was about 8 or 9 years, 2008 to 2016. So that's the period of the cartel itself. And the CCI went on to say that the parties ensured that they could increase the price of the product that they're offering, eliminate any price competition at all levels of the distribution chain. And they also ensured that they control the supply of the product itself in the market. So the CCI went on to say three broad things, and I'm going to repeat that. One, the CCI said that it led to increase of the product price itself. Second, it eliminated competition not just at the horizontal level amongst the three competitors, it also possibly eliminated competition at the distribution chain level in the downstream market, because they possibly controlled what the pricing of the downstream entities would be, and they possibly controlled what the discounting there may be. And this led also to a situation where the parties were able to control the supply of the product in the market. So when a party is able to control the supply of a product in the market, they can then ensure that there's price stabilization in the market, failing which there'll be very stiff competition and consumers may potentially be offered better pricing. So the CCI went on to penalize parties, very interesting over here. The CCI went on to penalize parties 1.25 times the profits of the entities for the duration of the cartel. So they did not look at the turnover of the parties. They looked at the profits that were accrued to them. And I just wanted to make sure I'm still audible because the webinar host has probably...
Yes, you are. You are very much.
So yeah. So the CCI imposed a penalty of 1.25 times of the profits that were accrued to the parties for the duration of the cartel. And because this was a lenient, so not only is this a cartel case, and that's why I wanted to cover this, this covers two broad heads. One, yes, it is a classic cartel case, but it is also a leniency case. And therefore, the first party which went ahead, which is Panasonic, they got a discount of 100%, which means that if the penalty obligation on the party was 100 crores, they had to pay or will have to pay zero if the case finally concludes. The second party, which is Everready, got a discount of a 30% as against a possible upward discount of 50%. And the third party, International, got a discount of 20% as against a possible discount of 30%. The CCI noted in its order that the discounts were given in this ratio to ensure, only because Panasonic had made a good disclosure and had ensured that it busts the cartel. The other two parties had not come forward with very significant added value. And therefore, the commission did not think it right to give them a discount of 50% to the second guy or a discount of 30% to the third guy. But they also wanted to make sure the leniency regime is operational and people like using this option available to parties. And therefore, they still gave Everready a 30% and International a 20% discount. So this is a very good case of what a cartel offense is and what the parties had done, did, and how the commission treated it, what the DG did in terms of the powers to raid the companies, and what the penalty obligations on the parties eventually were. This also gives us a good idea of how an association platform, and that's what the learnings are. Once in a while, a lot of companies sit on associations, and on these association meetings, they end up discussing stuff that they cannot. The name of the association is AIDCM. It is an association of batteries, dry cell battery manufacturers. And on this association, they discussed a lot of industry issues, which they rightly can. But according to the CCI order, and I have no direct evidence, they also ended up discussing these item points that they cannot, which is pricing, sales, marketing, strategy, discounting, royalty, rebates. All these in competition parlance are known as competitive sensitive information and cannot be discussed between competitors, because competition law wants to ensure that there is uncertainty in the market and that companies operate independent of each other. So that's the second case that we wanted to discuss. That's the first case that I wanted to discuss under Section 3 of the Act, which is anti-competitive agreements. The second case that I wanted to discuss today is cartelization in the aviation industry. I had very briefly touched upon it yesterday, but we'll spend a little more time today on it. So this case is with respect to cartelization between 3 or 4 airlines of the country. Jet Airways, unfortunately defunct now, SpiceJet, Indigo, where the parties for the period of 2007 or 8 to 2013-14 discussed a component of price called fuel surcharge, So if we look at the tickets that we buy, and I think the next time that we purchase tickets, we'll probably spend a little more time on that. There are various components that are there on the ticket itself. Base fare is one of them. Fuel surcharge is another component. There's queued fee, there's airport development charge, there are cesses, duties, there are certain other tax obligations. All of that collectively is then the cost of the ticket itself. Similarly, in the cargo segment, you have similar breakup. And then instead of base fare on a passenger basis, it is base fare per kg or per container. And then you have queued charges, you have ADC, you have FSC. FSC is a component of fare used by airlines, or used to be used by airlines, for the fluctuations that happen with respect to purchase of fuel, purchase of ATF, and with respect to the USD payments that they have to make. So to cater to that payment, to that fluctuation, they wanted to make sure that there is some sort of uniformity, is what the commission says. Between 2008-9 till 14-15 or 13-14, the parties increased their FSC, fuel surcharge, on 29 instances. So in a period of 5 or 6 years, there are 29 instances that when the parties increased the FSC. There were 5 instances in that period when the parties increased the FSC to the same number in the same period, which means all the 3 or 4 airlines increased the fuel surcharge by ₹1 each, or decreased it by ₹2 each in the same 15-day window or a 30-day window. Now, the ground realities were slightly different. Probably the commission did not understand or appreciate the arguments of councils. The ground realities were that under DGCA regulations and the norms that regulate the airline sector, airlines are required to disclose their pricing structure to the DGCA, I think 15 days or 20 days in advance, and also to the agents who operate. So all of us know this. There are various agents who operate for airlines, including Make My Trip, GoIbibo. They are all online agents. And then you also have physical brick and mortar agents sitting across the city. Those guys have to be told of the rate revisions on a 15-day advance basis. And then these guys probably once in a while speak with each other or are common agents, and therefore they have pricing data for all the airlines. And therefore, very quickly, all the 3 or 4 airlines possibly got to know of the other competitors' pricing and matched or mapped it. The parties tried to contest the findings of the commission and said that, the reason for parallel pricing is the fluctuations in ATF and the fluctuations in USD. But there are certain instances where the ATF had probably gone down, the cost of ATF had gone down, and the USD had bettered on INR terms, but FSC had still been increased by the 3 or 4 airlines. And that's where probably the commission thought that there isn't any rational basis for them to do this, but for having already agreed to participate in an alleged cartel. The airlines were penalized 150 odd crores. The matter went to appeal. The matter was remanded back to the CCI because the CCI had not followed certain principles of natural justice. The matter has now gone back in appeal to the NCLAT, the appellate body, and is pending at the NCLAT. The parties are contesting the penalties imposed on them, and we will hopefully see soon what happens over there. So that's the second head I wanted to capture with respect to cartels and Section 3 violations. I have, to recap, discussed 2 cases, the Jet Indigo SpiceJet cartel case and the case with respect to Panasonic International and Eveready in the market for supply of zinc carbon dry cell batteries. Of course, this is interesting. In the last 10 odd years, the commission has imposed over 14,000 crores of penalty on various companies. A lot of these penalties are at stays because of NCLAT not having decided it, because the Supreme Court not having decided it. So therefore, the actual penalty paid to the regulator or to the Consolidated Fund of India is not close to this number, but it still is a significant number. But roughly about 14,500 odd crores of penalty has been imposed by the competition regulator in India in the last 10, 12 odd years of its existence. The third head I wanted to cover today, and I think we're already 50 minutes down, and I should want to finish by 6:10 or 6:15, is abuse of dominance. Abuse of dominance, like we discussed, is a concept borrowed from the EU and the US. They have been, the US at least has a legislation that started way back in the 1890s. So the US jurisprudence is about 200 odd years now. The CCI has, and the Act has provisions under Section 4 of the Act with respect to abuse of dominance. The number of cases are not as high, but there have been a huge number of important cases that one can read and assess and discuss. I'm going to discuss, I've just noted down the names. I'm going to discuss 3 cases here. Probably I'll discuss 2 and then figure out if we have time to discuss the third one. I must highlight some of these cases have been stayed and are pending adjudication at an appellate level or at the Supreme Court. The first, but it's good to understand the concepts and good to understand what the penalty obligations were. The first case, and why I'm capturing this one, is how the relevant market was defined, is Shamsher Kataria and Honda Seal. So I'm so sorry, I'm just going to list out the 3 cases I'm going to discuss under abuse of dominance. The first one is Shamsher Kataria . The second one is Coal India. And the third one is yeah, there you go. So I'll just wait for a minute. I'll let all of you read Shamsher Kataria versus Honda Seal, Coal India. That's probably not the full name of the case, but that's how all of us use it as. And then Bel Air Owners Association versus DLF. That's the landmark DLF case that some of us may have read about in various economic dailies that we read. So I'm going to first discuss important to understand. The CCI assessed certain conduct of parties and assessed essentially 14 car companies for abuse of dominance. The commission was of the view that these guys had, offered excessive pricing for certain products and had offered certain abusive terms and conditions to its customers. And I'll tell you why the commission thought that each of these 14 car companies was dominant. That's the interesting point over here. So for all of us may know this, and it's public information. Maruti Suzuki is probably the largest player with about 50% odd. And then there are very small players in the market like Nissan, which probably will have less than a 5% market share. All the 14 guys were held to be dominant and to be abusing over here. And that's because the CCI looked at a very interesting market definition. They said that each car company is dominant in the aftermarket for the sale of spare parts, for the distribution of diagnostic tools, and for the services for maintenance that they offer. And I'll just stop for a second. What does this mean? The commission said that, sure, you might be a 10% market share in the primary market, in the market for sale of the car itself. So I may be Toyota, I may have a 15% market share, and therefore prima facie, I may not appear to be dominant. But in the aftermarket, once I've purchased the car, once I'm a locked-in customer, I have to necessarily, at least for the first few years when my insurance can be void if I go outside, I have to necessarily go to a authorized dealer, distributor, maintenance guy. And therefore I am logged in, and therefore in the aftermarket, in the market for spare parts, in the market for diagnostic tools, and in the market for maintenance services, all these respective companies were found to be dominant. The CCI's order was confirmed by the appellate body then, which was the Compat. And then currently it is pending at the CCI. Sorry, I'm so sorry. It's currently pending at the Supreme Court. Three car companies went ahead and got stay on the order itself. So we will have to see what eventually happens at the Supreme Court. There are very significant reasons why car companies feel that this is not good practice. They believe that once the spare part market is opened up for the world, there'll be a lot of spurious parts available in the market. And that's not what they want. They don't want spurious and duplicate parts to be sold. Number one, they want to ensure that all the diagnostic and maintenance services that one gives is up to the standards that the company is required to follow. And they probably have a fair point over there, because very often we see that, especially in smaller towns and cities of the country, we see that, spare parts are not authentic and they lead to accidents. They lead to a situation where the full vehicle becomes damaged, or they lead to a situation where multiple parts get damaged because of a spurious part which was inserted into the vehicle. Another interesting point that the CCI looked at is that if one were to assemble a vehicle, let's say they wanted to assemble a vehicle which costs 7 or 8 lakh rupees, if it was assembled in the after market, if it was assembled by you and me, it would cost them about 7 or 8 times more, because spare parts were being sold by these OEMs and OESs at 7 and 8 times the price that it was being sold to the car companies when they were manufacturing the vehicle itself. And therefore the commission found this to be alarming. They thought that companies are abusing their market, not in the prime market shares and market power, not in the primary market, but in the downstream market where they can exercise significant control over a logged-in customer like you and me. Compact confirmed, like I said, Supreme Court is yet to finally decide what they want to do, and therefore we'll have to wait for some time to see what finally happens. But yes, the CCI penalized them very strongly. They in fact gave certain other observations with respect to ensuring that the maintenance guys in the market are trained by car companies, to ensure that diagnostic tools are publicly and readily available. So a lot of other directions were also given by the CCI. One isn't sure if the parties or if all the car companies would want to comply. They ought to, but let's see what the Supreme Court finally does. And now, the second case I wanted to discuss very briefly, I think we are almost an hour done. The second case that I very briefly wanted to discuss was Coal India. This is slightly dated, if I am not wrong, it is 2014 or 15. Coal India, like all of us may know, is the largest company in the market for supply of coal to companies or to individuals in the market. Coal India controls about 90 to 95% resources in terms of the coal mines, and therefore they have very significant market power. The allegations against Coal India were that they were offering unfair terms and conditions in its fuel supply agreements or arrangements with its customers. Customers typically for coal companies would be electricity companies, discoms, and other such companies. Coal India was, of course, penalized a huge number, 1,700 odd crores. The matter again is uncertain. We don't know what will eventually happen, but the CCI went ahead and found the company to be in violation of law and found the company to be abusing its dominant position. Of course, it was upheld by the compact, the then appellate body, and it's pending, if I understand it correctly. So that's the second case I wanted to touch upon. Coal India found to be dominant and abusing its dominant position with respect to fuel supply arrangements that they enter into with their own customers, which are electricity manufacturers, discoms, and the like. The third case I wanted to briefly touch upon today is with respect to DLF, a large real estate developer in the country. The case name is Bel Air Owners Association. The case is on the fact that the CCI believes that DLF offers or offered back in the day unfair terms and conditions in the ABA. So a set of owners went to the CCI under the aegis of the association, and they said that whenever one wants to buy an apartment at a facility owned or by a company owned by DLF, the terms of the agreement are non-negotiable, the terms are lopsided, and the terms are highly onerous on the party purchasing the apartment from DLF. That's what the allegations were. The CCI probably interfered because they saw a larger issue with respect to how large companies in the real estate sector and otherwise operate. Otherwise, it was possibly a better case for a consumer body to look at. But I'm going to comment on what the CCI order says, and I am going to only discuss what the observations were in the public domain because we are counsels to DLF on the matter. A couple of observations. When the CCI looked at DLF, they only looked at the asset base and the revenues of the company. They unfortunately did not look at the debt that the company had taken or the other financial obligations that the company is bound by. And therefore, the CCI was of the view, and we would say incorrectly, that DLF was having very significant resources with respect to the asset base they had, the revenues that they had, and the land banks that they control. The second thing that is very interesting to note over here is the relevant market definition itself. So as a consumer, and that's me speaking as a consumer and not as counsel to a particular company, if I want to purchase an apartment or a house in NCR, I would typically weigh my options, not just in terms of the price points, but also in terms of where I want the product to be or where I want the apartment to be. So for example, if I live in, or if my workplace and my spouse's workplace is in Connaught Place, and I have, suppose, a child who goes to school in South Delhi, I have multiple options. I may want to live in South Delhi. I may want to live in Southwest Delhi. I may want to live in Gurgaon. I may want to live in Manesar. I may possibly want to live on the periphery of New Delhi and Gurgaon. So the options are multiple. And therefore, DLF was probably of the view that the relevant market definition should be slightly wider. I may also possibly want to move to Noida and live there if I want a larger flat at a lesser price. So it wouldn't probably be right for us to restrict the relevant market to as narrow as Gurgaon. And then surprisingly, and I'd again, not give my viewpoints on this, but the commission went on to say that the relevant product market itself was the supply or the services of certain high-end apartments in Gurgaon. So not only did they say that, the relevant geographic market is going to be Gurgaon, they also said that the relevant product market is going to be high-end residential apartments that the company offers in Gurgaon. And therefore, they narrowed down the definition very significantly and therefore found DLF to be dominant in that relevant market. And that's the critical point. They found DLF to be dominant, and therefore they thought that DLF could have abused its position by offering unfair terms and conditions. I will list out a couple of terms and conditions which the CCI thought were relevant. For example, the CCI said that DLF had unilateral power to change the terms and conditions. For example, the Bel Air case that we're speaking about, the company went on to add 10 floors to the building. So after these buyers had purchased the flat, of course, under construction, DLF increased the height of the building from 19 floors to 29 floors. And therefore, their contention was that if there is a common amenity, let's say in the nature of a swimming pool or a gymnasium, that offering will now be used by more number of consumers. And therefore, the price that the consumer had to initially pay was probably not right. That's one. Second, the CCI said that the ABA appears to be highly lopsided in the sense that if there was delay on DLF's part and it led to escalation in the cost of raw material or led to escalation in the cost of labor that they employ, the escalation itself will be borne by the consumer who's purchased the flat. They also had certain penalty provisions if there was failure to make payments to the company, and that failure would lead to a certain percentage of interest. However, if the delay was on DLF's part, then the interest obligations or the penalty obligations were significantly lesser. So it was not uniformly applicable to both sets of parties, consumers on one side and a real estate developer on the other side, and therefore the CCI imposed a significant penalty amount of about 600 odd crores. uh, there were a couple of very interesting observations that parties had made. One was with respect to the agreements itself. It was contested that the agreement was entered into prior to May of 2009. Uh, like all of us may know, the Competition Act came into force on 20th May 2009, and therefore any conduct prior to that couldn't be looked at. The CCI is of the view, and probably rightly so, that any agreement entered into prior to 2009 can also be looked at by the Competition Commission if it continues to be in existence, or if the conduct itself continues to be in existence, even if the agreement may have lapsed because of the duration of the agreement itself. So if two parties enter into an agreement in 1995, if it is in the nature of a cartel or abuse case, if the agreement itself subsists today, the CCI can go as far back in 1993 and look at the conduct. The penalties leviable will probably not go as far back, but the conduct itself can be assessed and recorded in the observations of the DG report or the CCI itself. The penalty has currently been stayed, and it is pending currently at the Supreme Court. So these are the three cases I wanted to discuss with respect to uh, with respect to DLF. I will now also discuss another case, which is probably the last one that I'm going to discuss today. These are all final orders passed by authorities. Of course, there are various other orders that competition authorities pass. One set of orders are 26(1) orders under section 26(1). 26(1) orders are orders where the CCI has found a prima facie view and then has decided to direct the DG, the Director General of the CCI, to investigate the matter. There are a couple of very interesting matters that the CCI is currently looking at. I'm just going to highlight two of them if somebody wants to read about them, but there isn't much available because they're 26(1) orders and not final orders, but it's a good start. It's a good read. There is a case against an online travel agency called Make My Trip and Oyo, where a company called Tribo and their partners have alleged that MMT has excluded them from listings on their portal and that they are imposing price parity clauses on them. All these orders will be shared with the readers through EBC if that's possible. We will try to circulate it to all of you after tomorrow's session, and you can go ahead. Otherwise, some of these orders are also publicly available on the CCI's website.
So we can do that. We can distribute the things. Yeah.
Perfect. The matter is currently being investigated by the commission, if I understand correctly, and we'll have to wait to see what the commission says in its final order. Another very interesting matter is with respect to Flipkart and Amazon. It is a case filed by an association against their abusive terms and conditions. The matter is currently stayed by the Karnataka High Court for certain lapses that the commission did when they came to a finding of a 26(1) violation. I think I'm now going to jump to a case by the Supreme Court of India. This is one of the very few final orders that the competition regime has seen, because it is a Supreme Court final order. I will very briefly explain to you why this case is relevant, but before that, I will give you the facts of the case. So the matter starts many years back when there is a case filed by an entity called the Food Corporation of India. They had moved an internal memo within the ministry, which had then also been circulated to the CCI for the investigation, where it was alleged that three entities, and I'm speaking from details available in the public domain, Excel Crop Care, UPL, and Sandhya, had cartelized in a tender floated by Food Corporation of India for public procurement of aluminum phosphide tablets. These tablets are used for preservation of food grains by warehouses and storehouses maintained by a central agency called the Food Corporation of India. Very interestingly, it not relevant from a competition law standpoint, but the government of India has tapped into the resources of the Food Corporation and is currently distributing free food and wheat in pulses stored in these warehouses by a state corporation, FCI. The CCI found that the three companies had cartelized on the tender itself. So when the tender was floated, they had possibly gotten together at a public forum or at the offices of the corporation itself and collectively decided what they want to insert in the tender. That is what appears from a reading of the public version of the order. And the CCI penalized them 9% of the total turnover of the entities. And I'm just going to hold on to that thought, and we'll come back on why I'm highlighting 9% of total turnover. The compact upheld the directions or the order of the commission, but reduced the penalty obligations. The matter finally went up to the Supreme Court, and it was decided by a bench of Justice Sikri, who's now unfortunately retired, and Justice Ramanna. The Supreme Court said a couple of very interesting things. And now I'll come back onto the penalty provisions that I was discussing. The commission had or has powers to impose a penalty of up to 10% of the turnover of the company. That's one part of the section, but I'm just going to restrict myself to that. So the law says that you can penalize a company 10% of the turnover. In this case, which we refer as the Excel Crop case, in Excel Crop, the bench said a couple of very interesting things, and they said that turnover, which appears in section 27B of the Act, should be read as relevant turnover, because that will result in more equitable results. They also said penalty imposed on relevant turnover will be more in tune with the ethos of the Act and the legal principles which surround matters pertaining to imposition of penalty. They also said that penalty cannot be disproportionate and that it shouldn't lead to shocking results. And therefore, the current legal position is this, that a company ought to be penalized on relevant turnover. Now, I'll just spend a couple of minutes on what relevant turnover itself is. Relevant turnover is turnover attributable to that portion of the business which has been investigated and which was part of the conduct. For example, there can be a multi-product company or a multi-product conglomerate. If there is a cartel in a particular segment, then only that segment of business should be penalized. So for example, if there is a cartel in the cement sector and there is a company being investigated that manufactures cement, but at the same time also has an airline and a event management company, then the commission ought to penalize this company only on the cement turnover and not on the airline turnover or the event management turnover that they may show in their books of accounts. And why is that critical? That's critical because you can't have shocking results. You can't impose such penalty obligations on a company that they result in the company itself, busting or leading to a situation where they fail to survive. And also they need to be proportionate to the harm caused. So if I have cartelized on a relevant market or on a relevant product, I should be penalized for that segment of business and not for every other business that I may be doing in the market. The commission on the other hand would probably think, and not wrong, they would not be able to catch hold of every conduct that a company may indulge in. Out of 10 conducts illegal under law, they may possibly get hold of 1 or 2, and therefore they want to set an example. They want the world to know that the penalty obligations are very severe, and therefore we will penalize you 10% of the turnover, and that will act as a deterrent not just for that particular company but for every other company wanting to indulge in anti-competitive conduct. one has to balance both interests. One has to ensure that, the anti-competitive harm caused because of a huge violation shouldn't be penalized to such an extent that the company is unable to operate in the market going forward. But of course, there should be significant pressure on them to not indulge in the conduct itself. So eventually, anyway, without bothering you with what my views may be, the Supreme Court has gone ahead and said that relevant turnover is what one will look at. And that's how the CCI is now proceeding to penalize companies. So I think I'm going to stop there. I'm going to take about 7, 8 odd questions, and then we will, take it forward from there.
Yeah. So, hello everyone. So we'll go with the questions. I think we'll start with the ones that came in the beginning. I've tried to sort of categorize them into the segments or according to their topics. So first one, of course, is a very basic question, but it's a difficult one to answer still, is determining the relevant product and geographic market. So how does one go about doing that? I
Sure.
think you might have covered some of that yesterday, but still.
So, right. So I did cover it yesterday, but for everybody's benefit and for the person who's asking the question, I will cover it once more. The relevant product and the relevant geographic market assessment is done on the basis of multiple factors. The relevant product market definition itself is not very easy to assess. One has to look at all the products and services which are regarded as interchangeable and substitutable in that market by the consumer. For example, and I will explain by examples that will be easier to understand. If I want to travel from New Delhi to Bombay and I have a meeting in the evening, the only option I have is to take a flight from New Delhi to Bombay, and that to a direct flight. And therefore, the relevant product itself over here will be offering of seats for air travel between New Delhi and Bombay. Similarly, if I have a cement plant or a steel plant, the commission has now gone ahead and said that each cement product or each steel product is different because the usage is different, because the costings are different, because the production facility itself used to make that is different, and therefore they're all different products, even though they're manufactured by the same steel company. For example, tubes and pipes are different from hot rolled steel or cold rolled steel. Color coated products are different from every other pins and needles that a steel company may make. So therefore, you have to see whether a product is interchangeable with another one. So for example, one can make a case, although it won't fly anymore, there is some jurisprudence in the EC and the US, that beer may be substitutable with wine because they are both intoxicants used for leisure intoxication. But there is some evidence now or some case law to suggest that wine is used by a different set of people for certain different age brackets and cost consumptions, and therefore is different from beer. But there can be a case made out that beer and wine are possibly in the same larger relevant market. A candy and a chocolate could possibly be in the same larger market unless one is able to establish that a candy is used by a small kid and a bar of chocolate is probably used by a different segment, or that they have different price points, or that they have a different consumer preference. So you have to see if the product is interchangeably used by the regular consumer. And if the answer to that very basic question is yes, then they are part of the same relevant market. Otherwise, they're possibly in different relevant markets. The relevant geographic market itself is the geography in which those products can be sold. So in the airline example that I gave you a short while back, if I have to travel between New Delhi and Bombay, the relevant geographic market will be all airlines flying on the OND, the origin destination pair, New Delhi, Bombay. And therefore, market assessment and market share calculation will be done on that relevant market. Relevant geographic market, for example, in the steel sector or in the cement sector, will typically be a 500 or a 700 kilometer radius from the plant itself. That's because transportation costs go up exponentially as soon as steel or cement is transported beyond a 500 or a 700 kilometer radius. So that's how one assesses the relevant markets, which are the relevant product and the relevant geographic markets.
Yeah, so related to this was the question on the DLF case. So
Hmm.
why was it that they took the geographic market in that case rather than, I guess, the product market? Doesn't make sense, but yeah, you can still go ahead and explain.
Sorry, can you come back on the question? I lost you in the middle.
The in the DLF case, why did they take the geographic market? Why did they consider the geographic market in that
Okay.
case?
So in the DLF case, the relevant product market itself was those high-end apartments, and the geography that they took was Gurgaon. They were of the view that if a consumer, and rightly so, if a consumer wants to purchase an apartment in Gurgaon, he will potentially not want to travel to New Delhi or Noida or Greater Noida. And they had valid reasons to say that, and therefore they probably thought that the relevant geography is Gurgaon, because a typical consumer living or and working in Gurgaon will not buy an inventory in another adjoining city.
So the next question is with respect to vertical integration. So one is how do we calculate combined shares as a vertical level at a vertical level?
Good question. So I think this is with respect to the choice of form. How does one decide whether one will use a Form 1 notification or a Form 2 notification? It is basis your market shares, the combined market shares at the horizontal level, that's one, and basis your market shares at the vertical level. Vertical level means, for example, I may be a manufacturer of steel and I may be buying a car company that uses steel. So then I will add the market shares of the steel player with the market shares of the car company at the vertical level. If collectively they breach 25% in any relevant market, I'm repeating that, then the CCI will require you to make a Form 2 notification.
Uh, so the next question here is what is the concept of single economic entity?
So if a group of entities is controlled by the same parent entity or the same promoter, then they are part of the same single economic entity. There have been a set of cases where the CCI has said in cartel offenses that even though you were part of the same larger group, but you projected to the world that you're two independent entities, and therefore you shouldn't now say that you discuss these price points or tenders because you were group entities. You projected to the world that you are different legal entities, and therefore you bid separately. And because you bid separately, now you have to act independent of each other, and you shouldn't have entered into any anti-competitive conduct in the nature of discussions of pricing and any such thing. There have been a few other cases along these lines where the commissions have assessed the concept of single economic entity. I'm happy to share those cases if somebody is interested with EBC, who will then probably share it with you guys. Essentially, any entity, very simply put, controlled by the same promoter can potentially discuss within the company, unless if they are otherwise projecting to the world, either by way of a tender or by way of any other means that they are competitors in the market, in which case then they possibly cannot. Otherwise, it should be okay.
Sure. The next question is with respect to the CCI. Can it take up suo motu cases?
Yes, that's a very good question. I'm glad you asked, whoever the gentleman or the lady was. The CCI has very vast powers. They have powers to initiate suo motu investigations. In fact, they've done it quite a number of times. They can look at any newspaper reports. They can look at any other news articles that appear in magazines. And if they feel that it is a fit case for an investigation by the DG, they can order a 26(1) and direct the Director General of the CCI to cause an investigation.
The next question is with respect to the IBC code. Does one have to notify a deal under the IBC code?
So yes, all large transactions that breach the financial thresholds prescribed under the Competition Act, under Section 5 of the Competition Act, can be and ought to be notified at the CCI, even if it is a matter under insolvency, because the relevant regulations mandate insolvency matters to also be looked at by the CCI. Of course, the CCI has internal procedures to ensure that they're expedited and that the approvals aren't delayed because of the long stop date that IBC matters otherwise have. The financial thresholds are prescribed in the law under Section 5. They can be revised by the central government, and they have done it in the past, where they look at the wholesale price index and other parameters, and they feel that the threshold should be revised, and therefore it is revised.
There's another question with respect to now the interlocking directorate in competition law, and what is the relevance of that?
So I think so I haven't seen the question, but I think this is with respect to my discussion on the IHH Fortis case. I'll just give all of you a little background again. In the IHH Fortis case, there was a joint venture entity controlled by a Fortis Group entity and by Apollo, which is a competing company. The CCI wanted to ensure IHH and Fortis were combining and merging. They wanted to ensure that there isn't information exchange between the Apollo Group on one side and the IHH Fortis Group on the other side. And therefore, they wanted to ensure that the directors sitting on one side do not also sit on the Apollo joint venture as Fortis or IHH nominees. And therefore, they wanted to make sure that that firewall is maintained. And they also wanted to ensure that there's no information exchange between the two directors from the Fortis side or the IHH side sitting on the IHH Fortis board at one side and on the Apollo board on the other side. And therefore, that was what the commission said. And they believe that this leads to a better competition in the market amongst the market participants.
So the next question is with respect to the associations that you had mentioned regarding the airline industry. So whether the CCI can prevent entities from participating in such associations, basing its argument to prevent future possible anti-competitive conduct.
So the CCI okay, good question. And I'm going to just elaborate on the question myself a little more so that it responds to a wider audience. Can the CCI pass orders across board even if a company is not being investigated? The answer is no. The commission has powers, unlike the MRTP, to only pass orders against an opposite party being investigated. And therefore, the commission can tell an association not to indulge in that conduct going forward. So for example, in this case, the commission, I don't know if it did, but could have told the Dry Cell Batteries Association to not allow market participants to discuss pricing, strategies, discounts, rebates, targets, and any such information. That is something that the CCI can do, but the CCI cannot pass a general observation qua the world that no association shall ever discuss anything. It can, of course, issue advisories, which it does. It can issue, annual reports, which it does. It issues booklets. It issues a lot of videos, which through its competition advocacy wing, which tells companies of what it can and can't do, but it cannot enforce that advisory without having investigated a company and without having given that company an opportunity of being heard.
So the next question here. So would you like to talk about the Facebook and Geo deal at all? Some people who are asking about that.
Sure. Okay. I will discuss that. Why don't you just give me a few questions that you think are relevant?
Okay.
And
Sure.
which is optimal.
All right. So there was one with respect to principles of natural justice. What are the principles that are applicable here? But I think there'd be the normal principles of the usual principles of natural justice.
I'll still cover them.
Yeah. So you could take that the movement of right to repair against Apple. So what do you think of that? What do you make of that? So then with respect to the COVID scenario where you have certain retailers who are selling these N95 masks at a higher price, could that be challenged? And then what if a company has a subsidiary working in the same segment? Is this included while calculating relevant turnover?
Sure. I'll cover these 4 or 5 points and then we can probably take 3 more questions after that.
Yeah.
So I'll take the simple ones first. PNJ. The principles of natural justice are nothing but uh, ensuring that the parties are given an opportunity, for example, to represent themselves. They are given an opportunity of being heard. They are given an opportunity to rebut any submission made against them. If those opportunities are not given to an entity, or if they're not given a hearing if they've asked for it, all these lead to a situation where an appellate authority will direct the CCI then to give the party an opportunity of reviewing relevant paperwork, give the party an opportunity of assessing what the relevant documents are and to respond to those. So this is essentially what the principles are, that you will not penalize a company or an individual without giving him a due opportunity to represent his case and look at relevant documents that he requires to look at. So that's PNJ for us, principles of natural justice. Uh, if there is a subsidiary in the same line of business, yes, the commission will typically look at consolidated books of accounts. So it will look at an entity and any downstream entity that the parent entity has, if it's in the same line of business, when it is assessing the market share, when it is assessing the penalty obligations of that company. So that is the question on whether one will expect the CCI to penalize a corporation if and the corporation on a consolidated basis if the downstream entity has the same line of operation. COVID-19 N95 masks being sold at a higher price, that is already being reviewed by the legal metrology department and by the pricing regulator in India, even though I think, so this is not my area of law, but I think that the pricing regulator has gone ahead and said that they do not have authority, and I read a statement by the chairman of the pricing authority that they do not have authority to review this, but I know that the legal metrology department is looking at it. The CCI can look at similar conduct if one can establish an abuse case or an anti-competitive agreement case in the nature of a cartel agreement or in the nature of coordination for allocation of customers or territories. The CCI will not typically sit on judgment on whether a price point is the correct price point or not. Only time will tell if they actually start interfering here, but typically on a broad principle level, the CCI is not a pricing regulator. It is a market regulator for competition. So they will look at conduct of the parties for sure. They have in fact issued advisories a week or so back that companies shouldn't take advantage of the COVID situation. They shouldn't price beyond reasonable levels. They've given a broad advisory. But will the CCI sit on judgment on whether pricing was correct or not? Difficult to say, but typically not.
Okay.
Facebook Geo, sure, I'll cover what little I know about it. The transaction ought to be notified to the CCI if what I hear. Facebook Inc. has picked up a 9.9% stake in the relevant Geo entity with certain additional rights in the nature of both seats possibly, and therefore the transaction will have to be notified. The relevant markets right now are not known to anybody except probably the councils working on the transaction. It is an interesting matter to see from a competition standpoint, not just because Jio has a huge consumer base in India, but also because Facebook and Jio both sit on a large amount of data that they have in control. And therefore, one will have to see how this data is being used by the parties going forward. One will have to see and ensure that, it does not lead to a situation where they use data in a manner that it leads to exit for other players operating in the market. But only time will tell, and we'll have to wait to see what the CCI does on this deal. There isn't any material available on how or what the CCI is going to look at because the filing probably hasn't gone through yet. The Competition Commission is, as I said at the start, working on a bare minimal stuff and is operating on very critical time-sensitive matters. They will possibly also start accepting filings 3rd May onwards. Regular filings, they're accepting certain other filings called green channel filings, where the parties have done a self-assessment that the transaction doesn't need a full-fledged investigation by the CCI, and therefore they feel that they can go through the green channel route, which is a route where a transaction is deemed approved the day it is notified to the CCI, unless if CCI reverts back to you. So green channel transactions are being notified. A regular transaction is not being notified as I speak today. I'm happy to check the relevant notifications again. But most probably 3rd May onwards, the CCI will start accepting notifications, and hopefully the Facebook Geo deal will get notified at that stage. Sorry, I didn't quite get one more question that you said, right to repair. I didn't follow what the question was.
So there's this movement against Apple that you have the right to repair Apple products, or you should be free to repair those Apple products on your own. And I believe because the restrictions that Apple has on being able to repair its products. So whether that is anti-competitive, I am also not fully aware of the exact issue, but
sure. So I'll respond to what I think is the CCI's position on this with respect to the auto parts matter, where the commission has said that you should make repair open to all. You should train personnel. You should ensure that they have the relevant documents to understand. They have all the material which is required to do the repair work, and therefore similar assessment ought to be done if this issue was brought to the commission's notice. I'm not sure if the commission is currently looking at a case against Apple on this point. I'm happy to check on that, but I think the commission would say the same thing if there were a case, that you should have a broad-based policy of allowing third-party repairers to operate if they meet certain criteria, if they are trained, and if they know what to do.
Okay. Next question here is with respect to a joint venture. So any information that is disclosed during a joint venture or a strategic alliance, whether any of that can violate anything under the Competition Act?
So joint ventures, unless if they are greenfield joint ventures, have to be notified to the competition authority for a merger control approval. If you're asking from a merger control standpoint, I'm not sure if this is from a behavioral standpoint, but I'll respond. So from a merger control standpoint, a transaction has to be notified to the CCI if the financial thresholds are met. So if tomorrow there is a situation where, let's say, Reliance Industries Limited, and this is a hypothetical, I'm not aware of any such transaction, enters into an arrangement with Tata to produce PPEs in the market, that joint venture will possibly have to be notified if, of course, the de minimis test is met for the entity, and of course the financial tests are met, which ought to be because both are large parties. The CCI will assess the transaction and will hopefully be an easy assessment and an easy approval, because the market shares of the parties in that relevant market will be negligible, if not zero, and therefore an expeditious approval will be given.
Okay. The next, I guess you could then take the last one or two questions which are here posed.
So I will quickly scan through this, and I'll probably take 2 more questions, and then I'll probably end the day today.
So are you taking the questions? Which is
I'm just going through the questions. I'll probably pick 2, and I'm sorry if I missed something which is more important. There are lots of them over here.
Yeah, so there are quite a few questions. So obviously we can't really go through. So
I'll probably go through some at the bottom, and we'll try to.
Those are the ones that you can just go through now, because I think we are also running out of time a little bit. I've tried to give you the most important questions over here. Okay. I have left out a few. I'm sorry. But for that, I guess they can write to you, or we can then forward those questions to you and you can respond or ask on social media. Yeah, so and we'd be happy to respond.
There is a question by Sandesh. He wants to know what is a clean team and if any clean team agreements have been contested at the CCI. So typically in merger transactions, there is a lot of competitive sensitive information that flows between parties. Now, if the entities are competitors, for example, if there is a tire company buying out another tire company, till the time the CCI approval does not come through and closing hasn't happened, they are supposed to operate as competitors in the market, which means that any competitive sensitive data, pricing, logistics, sales, number of trucks available, number of the inventory available in the plant, all of those details cannot go to the target entity and vice versa. But it is also essential that the target entity understands what the deal is and the acquirer understands what they will have to do going forward. And therefore, they set up a clean team. A clean team is nothing but a set of officers from both sides who agree not to participate in critical functions of their parent entities, and that they will be the guys who will be able to review all competitive sensitive information of the other party and take strategic decisions for especially the period day zero onwards, when, or day one onwards, when integration has happened and closure has happened and the parties are going to operate as combined entities. So that is what a clean team is. Most large transactions that we do have a clean team in place. It typically has a couple of participants at the senior management level from the acquirer side, 2 or 3 participants from the target side, a couple of lawyers on the target and the acquirer side, and a group of about 8 or 10 people, and sometimes even bankers on the transaction. They then take a call on critical functions that they otherwise couldn't have, because they are supposed to operate as competitors in the market and they can't then look at details that they otherwise need. And that's the purpose of a clean team. We have never come across a clean team agreement being challenged at the CCI. It's at least not available in the public domains. It has never happened to the matters that Lustra has done as a firm. So my view, we've never seen a dispute at the CCI with respect to a clean team agreement. My views on DLF, yes, I would want to respond to that. I am not a counsel to DLF. Yes, my firm represents DLF on this matter. I have tried to put across what the views of both parties are. DLF on one side, the flat buyers on the other side, the commission as well. Probably slightly biased because I hear the arguments all the time. So sure, I'm happy to take that and go forward.
We've done most of them. So there is, of course, earlier there was whether uh, to notify under the form to notify the combination is the market share for both relevant product market and relevant geographic market to be taken into consideration.
So, I'll just clarify that the market shares that you take is after assessing what the relevant market itself is. So you have to first assess the relevant market, which is a combination of the relevant geographic and the relevant product market. After you've done a full-fledged assessment of the two combined is when you come to a market share figure. And then you have to use that market share figure to figure out if it is a Form 1 or a Form 2 transaction. Okay, I want to respond to, because there are lots of students who've joined, I want to respond to one question. What are the books that one can read? I think given the nascency of the regime, we are about 10 years old, one should probably try to follow all the orders that the Commission, the NCLAT and the CC and the Supreme Court has passed and is passing over time. There are a lot of, there is a lot of international material available, which is probably more elaborate. For starters, there's a book by Richard Wish, which is quite good. That's a good starting point. And then you have books like Bellamy and Child. You have books like Fall and Nick Pay. They're slightly expensive, but they're very good books used by practitioners more often and not by students, but they are very good books. I'm sure Abhinandan would be a better guide on that query of what the relevant books there may be. And I'm sure he'll be happy to help you if they're good competition books that are available in the local market.
I'll write to you. I'm not aware of them offhand, but of course there are certain EBC publications as well, so you can look it up on our web store. There are other certain great publications. I found one on economics for competition law, which was great. I'm forgetting now which is the thing, so I'll write to you all along with some of the answers to your queries here. I think it's now time to end the session, unless Rudesh, you want to take any particular question over here.
So I will want to take one question. Looks like a good one, and I'm sorry, I'm not saying others aren't. I haven't scrolled through all of it. There's one question from Rahul Jain. Thank you for writing in, and I'm going to read out his question if somebody has missed out. Can the CCI initiate further inquiries on the basis of documents turned in as part of a leniency deal, or forward that information to any other law enforcement agency for a violation of any other law? Excellent question. I'm happy you asked. First, the CCI can look at any other cartel or any other anti-competitive uh, agreement or document that they see while they are reviewing a leniency filing. Of course, if it's the DG, he'll have to go back to the CCI and seek permission. They can't just suo moto start another investigation, but they possibly can look at other documents. Second question, second part, can they legally give off relevant details to another regulator? For example, the Enforcement Directorate, for example, income tax. There isn't, well, the DG office will typically not do that. They do threaten, I shouldn't say threaten, they do once in a while, pressurize parties to own up to violations, failing which they tell parties that they'll, disclose these details to the other relevant regulator. But I've never come across them having done this. They can go to the Competition Commission itself, and then the commission can take a view as to whether they want to refer the matter to another authority or not.
So there's one more last question. Has the CCI recently voiced any opinion on data as a factor for quantifying dominance in the market in any particular case?
So Jyoti, Garg, I'm happy you asked. They have looked at data as a factor for a couple of deals that we have done in the past, and they had passed certain directions on the parties. But there isn't any public document that would say, hey, this is how we're going to assess data. Yes, they've done a market study for the e-commerce sector where they've said that, what are the types of conduct that they would want to look at? What is the type of self-regulation that they expect parties to do? But beyond that, there isn't any opinion they've put across in the public domain that suggests to the factors that they'd look at when they're quantifying dominance in a relevant sector like digital economy and e-commerce. So I think we are almost done. Abhinandan, I think we should.
Yeah. So I think in the end, let me just share with you our own platform. And of course, there's also a relevant course that we have on our platform for those interested in competition law. So here we have, so this is our platform, EBC Learning. So you may want to subscribe to this. We have plenty of courses here. Of course, the one which is relevant for competition lawyers would be Economics for Competition Law. It is by Yugang Goyal. It covers a lot of basic, concepts like market power, etc., dominance, abuse of dominance, and what are the other methods of estimating market power, etc. The relevant market, how is that to be identified? So all of that is covered here. Then, of course, in the end, do please subscribe to our YouTube channel. You will, of course, get the updates for all our webinars here, including the ones that we've done earlier. So, and then, of course, to follow us on our LinkedIn, Facebook, and then Twitter channels as well. Again, you'll be updated on all the relevant posts that we have here. So that's it for today, I think. And thank you all very much for this session. Thank you, Rudresh. Thank you, all participants. Yeah. Thank you very much.
Thank you very much. Thank you, everybody, for joining in. Thank you, Abhinandan, for moderating this. Thank you.
Thank you. Thank you. Have a good day.
You too.